अभी तो सब सो रहे हैं। हेलो। तो 51 लोग लाइव जुड़ चुके हैं। आप सभी का स्वागत है झारखंड नज़र यूट्यूब चैनल पर। तो अभी थोड़ा सा म्यूट किया गया है सुप्रीम कोर्ट में, थोड़ी देर में स्टार्ट होगी। अभी देख सकते हैं सभी लोग अभी आराम फरमा रहे हैं, जितने भी वकील लोग हैं। तो हमारी आवाज़ क्या आप सभी तक जा रही है? प्लीज़ कमेंट करें। दीपक कुमार जी, ओके। तो थोड़ी देर में भविष्य निर्धारित होगा। जितने भी टीजीटी कैंडिडेट हैं या फिर पीआरटी के हैं या फिर पंचायत सचिव के हैं। रानी शर्मा जी, आप पंचायत सचिव कैंडिडेट हैं। हे भगवान, आज अंतिम सुनवाई। सही बात है, क्योंकि काफ़ी दिनों तक छुट्टी होने वाली है, विंटर वेकेशन सुप्रीम कोर्ट में। तो काफ़ी ज़्यादा इम्पॉर्टेंट है आज की सुनवाई, चाहे वो नॉन ज्वाइंट टीजीटी कैंडिडेट्स के लिए हो, चाहे पंचायत सचिव के लिए हो। हालांकि सुप्रीम कोर्ट के द्वारा जितने भी पिटिशनर बने हुए थे, सोनी कुमारी एंड कंपनी एंड जो भी ज्वाइंट टीजीटी कैंडिडेट्स हैं, उन सभी को तो सेव कर दिया गया है। लेकिन जितने भी पंचायत सचिव कैंडिडेट हैं या फिर जितने भी नॉन ज्वाइंट टीजीटी कैंडिडेट्स हैं, उन सभी को ऐसे ही छोड़ दिया गया है बीच मझधार में। तो कभी लगता है कि इस करवट आएगी, कभी लगता है उस करवट। तो आज देखने वाली बात ये होगी कि हालांकि आज हमें तो लगता है कि मूड सही है, मूड सही लग रहा है आज जज साहब का, तभी तो बोले कि थोड़ा सा हम इसको देख ही लेते हैं डिटेल से। और सभी को मौका भी दिया जाएगा। यहाँ पर जितने भी वकील हैं उनके द्वारा ये भी कहा जा रहा था कि पूरा यहाँ पर जमात आ गए हैं लोग, मतलब बहुत बड़ी केस है उनके नज़र में नज़र आ रही है। तो जितने भी लोग हैं बेस्ट विशेष दीजिए आज के लिए। जितने भी नॉन ज्वाइंट टीजीटी कैंडिडेट्स हैं, जो भी मेरिटोरियस कैंडिडेट हैं, जो भी पंचायत सचिव कैंडिडेट्स हैं, तो अभी हियरिंग स्टार्ट नहीं हुई है। हाँ, अभी तो देख रहे हैं कि लोग अभी आराम कर रहे हैं। थोड़ी देर में स्टार्ट होगी। हालांकि बोला गया था कि 2 बजे के बाद, तो हम लोग तो इंतज़ार ही कर सकते हैं, ज़बरदस्ती उनको उठाकर नहीं ला सकते हैं। तो मैच स्टार्ट होगा कुछ ही देर में। अभी देख सकते हैं सभी वकील लोग अब आ रहे हैं, धीरे 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 जमावड़ा बढ़ रहा है। यहाँ पर अजीत कुमार सिन्हा जी आ गए हैं। अजीत कुमार सिंह सिन्हा जी, ये राइट कॉर्नर पर हैं, राइट मिडिल कॉर्नर, बिल्कुल बेस्ट विशेष। आप सभी का स्वागत है। जितने भी 140 कैंडिडेट लोग जुड़े हुए हैं, जो भी इंतज़ार कर रहे हैं अपनी नौकरी का, आप सभी का स्वागत है। तो 140 लोग जुड़ चुके हैं। प्लीज़ सभी लोग लाइक कर दीजिए फटाफट। मात्र 10 लोग लाइक किए हैं, तो एक तरह से ठीक भी है। थोड़ा देर में स्टार्ट हो रहा है, तब तक आप सभी से बात भी कर लेते हैं। बात करने का ऐसे लाइव में मौका नहीं मिलता है आप सभी के साथ, तो मौका मिला है। उसके बाद हमारी आवाज़ कहाँ से सुनिएगा। विवेक कुमार नाम है मेरा। कौन कौन हो गए अब यहाँ पर देख सकते हैं। अजीत कुमार सिन्हा जी बैठ गए हैं। अब जैसे ही यहाँ पर देखिए, कपिल सिब्बल जी जब आते हैं तभी माहौल स्टार्ट होता है यहाँ पर, नहीं तो बोल दिया जाता है अगला डेट। तो कपिल सिब्बल जी आएंगे तभी यहाँ पर स्टार्ट होगा मैच। समझिए तो कप्तान वही हैं, और बिना कप्तान के मैच नहीं होगा। हाँ, सत्य में हो जाते। हाँ हाँ, बिल्कुल बिल्कुल चुप रहेंगे, अभी बोलने का मौका है थोड़ा सा। तो वहाँ पर जैसे ही हालांकि हियरिंग स्टार्ट होती है तो आवाज़ आने लगेगी, तो उधर से आवाज़ जैसे ही आएगा हम चुप हो जाएंगे। हम वकील थोड़े हैं, हम तो मीडिएटर हैं आप सभी। आप सुप्रीम कोर्ट की सवाल उठाइए बॉस। सुप्रीम कोर्ट के खिलाफ, हाई कोर्ट के खिलाफ तो मुश्किल ही है, तो सुप्रीम कोर्ट तो बहुत ही बड़ा है। 170 लोग जुड़ चुके हैं। आप सभी का स्वागत है झारखंड नज़र यूट्यूब चैनल पर। अरे भाई स्टार्ट होगा, विनय कुमार साहू जी स्टार्ट होगा तो शांत हो जाएंगे हम, ठीक है। हाँ तो अब स्टार्ट हो गया, अब हम शांत हो जा रहे हैं, ठीक है। बहुत बहुत आप सभी के लिए बेस्ट ऑफ लक।
We have got ready one page note also. We have one page note also. Lordship stick. 53. Now, I'll be very pointed. Your Lordship's kind permission. What is it, William? Yes, straight away. Kindly just take that and change to this one. It's an MA within a very narrow compass. I'll give you Your Lordship the points, the point form and the pages. First, kindly note that my request today is nothing to do with change in law, which I have succeeded in. Point one, Lordship should know what it is not about, rather what it is about. There I'll come to in the end. So it is not about change in law. Number two, I'm sorry, my Lord is then number two, it is not about compensation for change in law, which after torturous journey, I have succeeded in finally.
एक बार कमेंट कर दें प्लीज, आप सभी के पास आवाज जा रही है?
Very torturous, agonizing journey, but yes, I have ultimately succeeded after a long, long time. Anyway, that I tell you. Number three, it is not about interest on that compensation which has to come on change in law. That is inbuilt. That also, Malus. Now, this is about LPS, late payment surcharge, namely, after your Lordship directs that pay, the process of your Lordship's directive and then contempt and then paying and then actual paying, it's taken an enormously long time, so I am entitled to under a clause LPS. That also is not an issue. After a lot of banging my head on this thing and requesting them, I have got that also. LPS, that is late payment, that's the fourth thing I got. So why am I troubling your Lordships? I am troubling your Lordships because the issue is that admittedly they have to pay me, and I use the word admittedly, LPS at 9% SBR plus 2%. That is the state bank or the notified rate, whatever it is, it varies, plus 2%.
As per which clause?
Yes, that's it. I'll show the clause. Versus them paying me at 9%. So they accept they are paying, but they don't pay me at SBR as per that. That's the short point to say. So your Lordship will just see the points in respect of that. Your Lordship's query, it is payable as per clause 8.3.5 at page 280 of the PPA. 8.3.5 page 280. 280. May I read this? In the event there is delay in payment of a monthly bill by the procurers beyond its due date, a LPS, late payment surcharge, shall be payable by such procurers to the seller, that is me, at the rate of 2% in excess of the applicable SBR per annum on the amount of outstanding payment calculated on a day-to-day basis and compounded monthly rest for each day of delay. The late payment surcharge shall be claimed through the supplementary day. Now note just 3 dates or 4 dates.
हाँ रजनीश सिंह, इसके बाद जस्ट होगा.
Regulatory Commission order which gave me change in law is dated 17th May 2018. Let me just note the dates. I will not take a lordship's time. The dates are important.
जस्ट इसके बाद सोनी कुमारी केस का आएगा.
The judgment in appeal affirming that and one was giving me more relief because some amount of relief was not given, is 14,919. I'm not giving Lordship the pages because now it's not necessary. Then it came and was heavily contested in a Lordship's judgment in the Supreme Court, affirming my claim and affirming this judgment, is 31/8/2020.
Each court judgment.
Your Lordship's court judgment.
इसके बाद just
Now, review petition is dismissed of this judgment on 2/3/21.
हाँ बिल्कुल.
Each time 1 year passes, 1.5 years passes, etc.
Review dismiss on?
On 2nd March 2021. Still they don't pay, which is fructified from beginning. So I file a contempt. The order directing payment of the lump sum was the total, let's say, X plus Y plus Z, altogether 100 rupees. That is, fellows, your Lordship's judgment in contempt is 25 February 2022.
इसके बाद जस्ट स्टार्ट होगा.
So we have reached from Malas.
ये जितने भी लोग हैं तब तक शेयर कर दीजिए,
18 to
जितने भी
22.
आपके जो भी व्हाट्सएप ग्रुप होगा या फिर जो भी टेलीग्राम ग्रुप होगा.
Despite that order, Malas, it is not done. And finally,
और सभी लोग लाइक भी कर
your
दीजिए.
Lordship disposes of on 19/4/22. After it is done, the payment is made on 25/3/22 at 9% and not an SBR plus 2%. I mean, 2%, whatever the SBR rate plus 2% above that. So, whereas the payment made at the wrong rate is made on 25/3/22. Your Lordship may note that date.
According to the, what is the SBR?
Yes. The SBR rate has varied from 13, 14 to 15%, because the whole idea is that with respect to that rate, it varies. It is 13, 14, 15. And Manoj, just turn to a chart, it will make it very simple. In my rejoinder of page 6, at one place, Your Lordship will get all the facts. Page 6, my rejoinder. So Your Lordship doesn't have to go into any inquiry.
इसके बाद जस्ट आएगा सोनी कुमारी केस का.
Small. Yeah, that's a very thin one. Well, it's says rejoinder, 17th October 22.
13 page.
13th page. My lord is right. Please turn to page 6. The Lordship does not have to go into details, just note two figures. Third column at page 6 is amount paid by them as late as 25 March 22. Does my lord have it? Is 1478 odd crores. Amount required to be paid as per 8.3.5 is 2922 computed at SBI plus 2%. Difference is 1443. It is not disputed. None of this is disputed. The dispute I will show in a minute what it is. It is not disputed that I paid you at 9%. It is not disputed that 8.3.5 says this. And it is not disputed that these are the figures. Now I'll tell you what the defense is. Just give me 2 minutes more. The defense is principally two things. One, that you go here and there while you coming here. Because I took care of that. I expressly kept this issue of LPS open when I was before my lord, because that time we were calling for the money. We were dying in again and again asking, please give us the money. You're not giving it for 4 years. So that issue was kept expressly open in Malas. Your Lordship's order disposing of contempt on 19/4/22. I appeared, we said that we don't want trouble Lordship today, but please don't compromise my right to claim that. That your Lordship's order is 19/4/22, disposing it of at page 232. Need not go there, but Lordship will note first para. Already left the question open.
1 minute. 230.
232. This is the order of 19th April 2020. So please note, 8.3.5 is not denied. The rate being the difference.
Sorry, which page? Which page?
Well, the top.
ऐसी बात नहीं है.
232, internal page 4, it says that my lord has got that. As such since, does my lord have a sentence saying as such since?
हाँ, इसके बाद जस्ट स्टार्ट होगा पीएटी पंचायत जो सोनी कुमारी केस का जो कंटेंट.
We are not inclined to pass any further orders. We already left the question of late payment surcharge open. Can claim before the appropriate court. That's point one. Point two, Malas.
What is the appropriate forum?
Malas, the appropriate forum is it's a consequential order. Your Lordship is passing contempt orders 3 times. Over 3, Malas, this matter started in 18. It landed up in the Supreme Court in 19. You have no business to pay me in 22. Just by ultimately you have to pay. But I have to knock on the door. Your Lordship has to pass order after order.
वाह,
It's a consequential order, Malas. The clause matters. What matters is the clause. Is there a power?
हाँ हाँ, इसके
The
बाद
quantification matters.
अभी कुमार जी
Now the second argument is even more curious and a little important. Your Lordship's main order, Your Lordship remembers, is 31/8/2020, a date which my Lord just noted. The principal order of my Lords, affirming all this payment to me, is 31 August 2020. My Lord noted that in the list of dates I
देखिए
gave.
क्या मूड बना कर आए हैं जज साहब.
Now, in para 67, now in that bonus proceeding, there is no question of LPS. It has not arisen
क्या
there.
लगता है आप सभी को
Your
comment
Lordship
करें,
were
डेट का आगे नहीं
discussing
बढ़ना
carrying
चाहिए.
cost, which is interest, which is inbuilt into the clause, and compensation. I hope I am clear.
अगर
Also
डेट आगे
change.
बढ़ा तो
No
निश्चित
issue.
तौर पर 2000
But in a sentence, it appears that your Lordship has used a word which did not arise. So they are saying this is now decided by that. Turn to that page, it's para 67.
At page.
At page 161. Which file? Main file 161.
284 300 करिए इसको.
Relevant at 164,
अभी मेन
165
बात
को
की
just turn
नहीं
to that.
स्टार्ट हुआ है जी सोनी कुमारी वाला.
The
सोनी
main
कुमारी के बाद तो हम खुद सुनने लगेंगे ध्यान से. बोलने का मौका कहाँ मिलेगा.
Now this is Malas actually a using which is of a word which is doesn't mean what it says. Malas, your Lordship not dealing anywhere LPS. No LPS issue arose. This did
Page number.
para 64. No, 67. Well, it starts at 64. Just I want to show you what the issue was, and then I'll come to 67. Come to 64 at page 164. Para 64 at 160. The argument raised by Mr. Sundaram that carrying cost is a penal. So the issue was carrying cost, which is interest. We are not concerned. All along the fight was over compensation and interest, carrying cost. We are not concerned with it today, Malas. Cannot be accepted with a decision in Uttar Bijli, Haryana, in which respect to carrying cost, it was held that carrying cost was payable in terms of restitution. Carrying cost, that is another fancy name for interest basically, is to be paid on the same basis as provide for other dues. Now, Malas, please. Now let us come to 67. At page 167. So, Lordship may take it, the entire judgment is on compensation and carrying cost on compensation. Nothing to do with LPS. Lordship may take my word for it, we've checked up fully, Malas. Now just see what happens at the end of 67, which is being misused, Malas, by the other side, according to my humble submission. Last 6 lines, if my Lord will see in para 67. In our opinion, it would be appropriate to direct the appellant's Rajasthan discount.
Which page?
Well, I'm sorry. 167 is the page, 67 is the para number.
It starts with regard to the...
With regard to the question. So please see that. With regard to the question of interest late payment surcharge. Now what has happened is, they put an oblique. Interest is carrying cost, late payment surcharge is something totally different. But they put an oblique. So now see, Malas, the last operative portion of 67. They were not considering the issue. It shouldn't arise because the application, the request is made afterwards. Malas, kindly bear with me for a minute. When will I ask for late payment surcharge, Malas? With great respect, Malas, kindly consider. After the amount has become fructified, the amount became fructified only on 31st August 2020. Your Lordship's judgment for the first time came on 31st August 2020. So I could not ask for late payment surcharge. Now see the last 5 lines of para 67. Yeah, just read the, it will become clear if I read the last part of 67.
On page 1160 page.
Can I read 67?
One page.
अब क्लियर क्वालिटी जाएगा. ठीक है हो.
Part of 67.
अभी साइलेंट किया गया सुप्रीम कोर्ट के द्वारा है।
Two things. Mr. Sundaram's argument at that time was that we are concerned with the interest till the date your lordship finalizes on 31A. No question of LPS arises, it will arise later. See that at page 119.
No, only difficulty, Mr. Counsel.
That is LPS used, the word is used.
No, not that.
Yes.
Para 66 may be read.
Yes.
You believe this is para 66.
Yes. Liability of late payments. I'm reading after the quotation, Manoj, or should I read?
Para 66, considering the facts of this
The
case.
facts and keeping in view that RC and FTL have given concurrent findings with regard, with which we concur. We may now deal with the question of liability of appellants with regard to late payment surcharge. In this regard, the following articles which are relevant are extracted below. That is extracted. Liability of LPS, which has been saddled upon the appellants, is at 2% in excess of applicable SPR on the amount of outstanding payment, calculated on a day-to-day basis and compounded monthly rest for each day. Therefore, there shall be a huge liability of payment of LPS contracts and discounts.
Then read further.
With regards to the question of interest late payment surcharge, we notice that the plea of change of law was initially raised by APRL in 2000. A case was also filed by APRL 2002 itself. However, the appellant Rajasthan discount did not allow the claim regarding change in law, because of which APR was deprived of raising the bills with effect of the date of change in law. We are thus of the opinion that considering the totality of the facts of this case, in order to do complete justice and to reduce the liability of appellants, payment of 2% in excess of applicable would be on the higher side. In our opinion, it would be appropriate to direct Rajasthan discount to pay interest as per applicable so-and-so, which should not exceed 9%. Now mark the word, pay interest oblique LPS. Just mark that line.
No, it was after considering 8.3.5 counsel.
I appreciate
And considering taking into
Okay,
note that it will be a huge liability upon them.
Yes.
Thereafter consider that so far as the late payment charge is concerned, it may be 2% in excess of
अपना जो video quality है, थोड़ा सा अपना
SPR,
बढ़ा
but it
लीजिए
should not
अपना।
exceed 9%.
That
That is the problem.
Absolutely correct, Manoj. That's the problem. May I explain why, Manoj, it may not be a problem. I understand my loss very completely. The issue arising here till the end was only carrying cost. Carrying cost is a fancy word in legislative law for interest. Interest in that, Manoj, what they've done is they have taken LPS to be interest. Let me explain, Manoj. Change in law is 100 rupees. On that interest, till the time of the change in law, is 10 rupees. So 110. That becomes an invoice of 110. Now, if you pay 110 rupees to me after 10 years delay, then you will pay a late payment surcharge on the late payment. Now, they were considering only 110 rupees, not the late payment. Just see that at page 119. They were not even, what they have done was the oblique is a problem. They are saying
Not
interest.
oblique, Mr. No, oblique is not the only problem.
They've,
The discussion in para 66 is the problem.
well, they have quoted.
It's a specific.
And specifically stated that late payment charges 2% plus SBAR, correct? But in the facts and circumstances, to avoid any huge liability, it should not exceed 9%.
Because FPL used
68.
it was standard used. There is no clause for carrying cost. There is no clause for
That's what
my bad.
that's 68.
It is made when?
Let me this
1 minute, we will try to.
the actual payment is 25th March 22.
25th,
March 22. The confusion has arisen
As per
because they have taken.
9%, we've already paid.
sorry?
As per 9%,
No, no,
That's not the issue.
25th
No,
of
Mr.
March.
Mr. Counsel.
Yes, bro.
The point is assuming, correct, for the time being, you may be right. Correct? 66, 67, 68, you are considering 8.3.5, everything. But the liability accrued, correct, in 2020, it came to an end,
That's the point.
correct? This got directed you to make the payment at 9%, correct? Immediately on 31/8/2020, you were required to make the payment. You cannot continue to pay the interest at the 9% annum, correct? For the period even subsequent to 31/8/2020.
That's the problem.
See the difficulty.
But the difficulty
1 minute.
today, but
No. You may be right, mister, that so far as till this got passed an order, 31/8/2020, your liability to pay the interest at 9%, we may for the time being accept it. But what about the interest, the late payment charges after 31/8/2020, when the rights of the parties were crystallized finally?
Page 65. Para 65. Para 65. If you want.
Like post technical interest, which is LPS, they took 9%.
We may not say late payment charge from the day one, but at least you have to pay the late payment charge from 31/8/2020.
Page 65, para 65, page 165 is what I would say. I would read for your lordship. Now, what I'm saying today, my lord, is there are 3 judges, honorable judges of this court, including your lordships, who are a part of that bench. Today, my lord.
No, we accept, try to appreciate.
Only one more. Only one more.
But thereafter the division bench, thereafter 2 judge bench in contempt proceedings.
Five orders passed.
Has specifically kept the open with respect to that late payment charge open.
That's like every day your
We have to strike the balance between the two.
But that's like what your lordship is every day we're not doing. When your lordship is dismissing, but while dismissing, we ask for a relief, and the lordship says, okay, liberty granted, if will not advise so.
Okay.
That's precisely what has been done here.
Okay.
So, Lord, today say
anyway, but
we gave a right.
Okay, you tell us, correct? Why should we deny that late payment charges, correct? As per 8.3 from the period 8/3/2020 or 31/8/2020.
31 August. Two.
You tell us.
2 reasoning I gave out. But one, it should go back to the 3 judges.
No, it should not go because of the fact that
Secondly,
earlier the contempt was also by 2 judge bench.
4, 5 orders.
You did not take a objection at that time also.
We said.
No.
Our
On that day,
objection,
the contempt order is passed by 2 judge bench.
our objection was there to the effect.
In the Supreme Court, there is nothing like 3 judge or 2 judge, mister. That is for convenience, everything is. Virtually, unless the matter is referred. You concentrate on merits, mister, rather than on technical whatever.
No, it's not technical. With utmost respect.
Okay, we will consider it. What do you say on 31/8/2020 when the rights were finally crystallized and your liability to pay the interest along with 9% accrued? Assuming that late payment charge was 9% till this court took a decision. But what about for the period after 31/8/2020?
Page 65, page 165.
Please read. Please read.
It was argued that the RERC and the APTEL had not determined the amount. It is apparent that the principle has been worked out by the RERC as well as APTEL. Quantification directions have been issued to Rajasthan Discoms to verify the document, because our case was that they have not submitted those documents. Our case was they have to give documents of the coal procured, of the energy produced.
That was everything over, mister.
No, not
changing law, everything was over.
It was not. It was not. It was not. Let me read further, Lord. Quantification directions have been issued to Rajasthan Discom to verify the documents submitted by APRL and make payment in terms of the judgment and order. Nothing further was required to be done by the RERC as well as APTEL. So the Lordship goes on to say that it takes into consideration the late payment surcharge, it takes into consideration the interest. I mean, we filed a review.
You are right, Mr. But that is, Mr. Counsel, that is up to 31/8/2020. But what about after 31/8/2020?
I'll just find out.
आप शायद आएंगे.
One thing your lordship should know anyway.
Yes. So if your lordship will see, during the contempt jurisdiction, when they say that this money is due, but we said, based on our computation that we have done on the documents so given, 506 crore odd rupees was due from them, which is why your lordship said that if such a situation so arises, then please, this is not the forum, go to the appropriate forum. So our claims are also pending. We have not come before the court.
No,
under the
whatever your claim is concerned in appropriate process, it will be dealt with counsel.
Direction for them also, my lords. Kindly have the order, my lord. Once again, the contempt order.
Let us see.
Yes.
बस इसके बाद स्टार्ट होगा सोनी कुमारी केस.
In the prayer of the MA.
Have page 232, which was learned senior colleague.
Yes, we are having counsel. I am having counsel.
Yes, my lord. As such.
Read the entire thing.
Yes, my lord. At page 232 only, my lord, that will suffice if your lordship wants, I'll read the whole thing.
Read from page 22, 229 onwards. In compliance of this court order.
Sum of rupees 5,996.44 crores has been paid by the respondent discoms to the petitioner, which according to the respondents is towards the full and final payment in compliance with the court's judgment dated 31st of August 20. Dr. Singhvi's counsel for the petitioner submitted that out of total sum paid of so and so crores is towards the principal amount, 1,469 crores is towards carrying cost, interest, 9% per annum, and the balance amount is so and so is towards the late payment surcharge. So late payment surcharge, as per your lordship, 31st August, your lordship had said it will not exceed
9%.
It will not exceed
At the rate of 9%.
And your lordship specifically deal with that 2%.
Okay, Mr. We take it.
It is true. It is thus contended that there is no full compliance of the judgment of 31st August 2020 of this
No,
court.
one read this. According to the petitioner,
Yes.
the late payment surcharge ought to have been rupees 2477.00.
As per 2% surcharge.
And there is a substantial shortfall of over rupees
1,300 crores. It is thus contended that there is no full compliance of the judgment dated 31st of August 2020 of this court. Senior counsel has further submitted that the said payment is made, it is only up to November 2021. After the said period from December 21 onwards, the respondent has not paid any amount towards the principal or interest. Lastly, it is contended that in an affidavit filed by the managing director of RUVN, the respondent Rajasthan Utilities contends that it would be entitled to certain claims outside the judgment dated 31st of August. So they say outside, for which it seeks leave of this court to claim from the petitioner, which is vehemently opposed by Dr. Singhvi, learned senior counsel, as according to him, as per judgment of this court, dated so and so, quietus has been put to the litigation between the parties. Per contra, Mr. Sundaram, learned senior counsel for the respondent, has submitted that on payment of so and so, full compliance of the judgment dated 31st August has been made. It is contended that in the said payment, there is no component of late payment surcharge. What has been paid is the principal amount of 54,745 crores minus 2,426, which has already been paid. Rupees 3,048 crores plus 9% interest compound annually till March 2022, which comes to so and so crores, totaling of rupees 5,996. It is thus submitted that after the payment of interest, that's 9%, there is no question of late payment surcharge. As such, the issue raised by the counsel for the petitioner is not worthy of acceptance. As regards the second issue, which is, this is, I can skip, this is our requirements, and then kindly have page 232 now. Can I read 231 minute? Can I read 232 minutes?
Yes.
Your Lordship may read it to me.
Yes,
that's the division then. As such, since according to the respondents, the payment made is only towards the principal amount plus 9% interest per annum, we are not inclined to pass any further orders, as we have already left the question of late payment surcharge open, which the petitioner, if so advised, can claim before the appropriate forum. And your Lordship can decide which is the appropriate forum. If it is so, let it go back to the three judges or the bench, or let them go back to the actor.
No, which is we are considering from the,
or the
order passed by two judge bench counsel.
Yes, my lord.
Yes, Lord. And see, admittedly, the amount due was paid pursuant to the order of 25 to 2022.
MA is filed in this.
MA is in the civil appeal now. It's not in the contempt.
Correct.
It's not in the contempt.
Correct.
So, because it's there, it should ideally go back to three judges.
If the contempt can be heard by two judge bench, why the MA, Mr.? Try to appreciate.
Because this is a review.
Otherwise, the same thing will be done. It is not a review.
Let me read further, what our contention was. And why the court thought it fit to
No, we are not on that, Mr. You may be right. You are not liable to pay any late surcharge. Correct? Up to 31/8/2020, you may be right at the rate of 2% plus the SPR. Correct? Till 31/8/2020, we may not settle with the liability because that has come to an end. Either you listen to us or listen to him.
No, I'm listening to your Lordship.
Otherwise, it's a very difficult counsel.
I'm sorry if your Lordship done that.
Because
one sentence,
1 minute.
Sorry.
So we are, because admittedly the amount of this amount was paid pursuant to order dated 25/2/2022, though the order was passed on 31/8/2020.
Yes.
Correct?
Yes.
Which you were required to pay immediately on conclusion of the proceedings on 31/8/2020. So the question is only at present we are considering, not liability which has come to an end pursuant to the order of 31/8/2020.
I'll answer that. I get what the Lordship is saying. Let me just...
Now you satisfy us why, correct? The late payment charge from 31/8/2020 till the actual payment was made, correct? We are on partial relief, not the full relief which they are asking.
I quite...
In fact, they are asking for the entire late payment charge, which we may not grant because of the observations made in paragraph 65, 66 and 67.
Yes, Lord. But for putting forth my point, Lord, may I just read a little further? As regards the second question of the alleged compliance by the respondent after November 2021 of the judgment and order dated 31st of August 2020, we would not like to make any observation, as there is neither any material before us with regard to that, nor the same was in question when the contempt petitions were filed. As such, we leave the question open to be agitated by the petitioner if so advised. And go further, my lords. With regard to the last issue raised by the respondents, that is us. We also said that 506 crores is due to us because of this fact of the calculation and late submission of the bills, which is to the effect that the claim of the Rajasthan utilities against the petitioner outside the judgment dated 31st August 2020 be permitted to be made. We would only like to observe.
We are also saying the same thing, Mr.
Yes. So, but let it go.
Without even this, we have said that it will be considered in appropriate as and when you proceed, you have initially proceedings for recovery.
What is this prayer now in the MA? Let's see that also. Page 11, the MA, prayer in the MA.
We may not grant it, Mr. We will restrict.
So we have to ask for it. Off the cuff, my lord, if a my lord submission.
But that's how.
Kindly have his MA, my lord. For a minute. Page 11.
MA is filed by them.
Yes. Their prayer. Direct the appellant Rajasthan Discoms to make a late payment surcharge of 1,376 crores outstanding as on 30th of June 2022 to the applicant in terms, and how that figure was not reached, that my colleague was not, he read that out. So they are asking for the entire.
That is what we are pointing out, Mr. Counsel. We may not grant that relief at this stage, correct? But at least from 31/8/2020 we are saying.
I would say,
and your rights to recover the amount of whatever due and those are kept open, Mr.
But what I'm saying is, it should not be piecemeal. Your lordship may not.
No, but contempt court has already said.
The contempt court has said, whatever is before us, we have decided.
Correct.
And rest of things are open to them to go and claim before the appropriate.
No. With respect
the paragraph that I read just now.
No, that is what we are saying. This is with respect to your claim.
No, my claim is the third last paragraph.
That is what we are saying.
As far as the petitioner is concerned, it's paragraph 2.
Correct.
As regards the second question of non-compliance of the after November 2021.
But we are, Mr. Counsel, try to appreciate, we are not considering the entire relief from the date from 31/8/2020 2010. We are only considering from 31/8/2020.
ये थोड़ा सा लंबा चल रहा है.
I would say, an exercise should be done by the appropriate forum in toto.
What appropriate forum?
Because my claim today, we say that today your lordship.
No, there cannot be appropriate forum for the period after 31/8/2020.
Because it's continuing. The bills were not submitted. Kindly have again page 165, para 65.
Counsel, you paid the amount of on 25/2/2022.
They accepted without protest. They accepted.
No. They said that it was not. Otherwise, this observation would not have been there.
Kindly have para 65 again and 66. Read it in conjunction with.
Correct.
I'm sorry for being.
No difficulty.
And what I want to show is basically, my lords, 8.3.5.
Yes, Counsel.
It was argued that the RERC AFTEL had not determined the amount.
You are also succeeding. They are also succeeding.
But we are holding
late payment charge. You are succeeding for 10. I think not 10 years. More than that. 2010 till 2020.
No, we paid.
See a substantial, what substantial amount you are getting?
We have paid, my lord, in all 8,423 crores.
Correct. That is pursuant the order passed by the APTEL.
3,000 crores is the interest.
We are. That is bound to be there as per the contract and as per the order passed by this.
The pointers being given, my lord, to today to reopen, re-agitate by way of an MA.
That you are right, counsel.
By way of a content.
Anyway, we are again and again we have not to tell you, mister. You are right. Correct. Up to 31/8/2020, correct. There is a quieters. No dispute about it. No doubt it can be said to be. Only thing is after 31/8/2020.
8.3.5 if not to be
Yes.
again at page 165.
The payment was only thereafter.
No,
It shall be thereafter.
correct.
In the event of delay in payment of a monthly bill by the procurer. So the question is of those monthly bills, the submission has to be there. If the submission is not there, Lord, what do we verify? What do we check?
That was not even your case before the.
That was, my lord. That's what para 65 and other paragraphs say.
These I know, Mr. Distinctly recollect. Even I was not in favor of the 9% also. Correct. But ultimately, because it was.
Your Lordship read?
Yes. Yeah.
And now Lordship has come to page 166.
Page 166.
Yes. Why your Lordship did not give surcharge?
No.
Liability of late payment surcharge.
We have not refused. We have said it is restricted to 9%.
That's what I'm saying. So, in a way, your Lordship.
No.
What your Lordship is saying is
We
right.
consider 8.3.5. It will be a huge liability.
Excess.
Correct. And therefore, considering that huge liability, it is said that from the date on which the contract that till the appropriate decision is taken, it will be 9%. That late payment charge.
Whatever, but your Lordship and your wisdom.
We restricted it to the 9%.
Yes.
But till 31/8/2020.
So, I would say appropriate forum your Lordship may decide.
No.
Let all of us go.
Which you tell us which appropriate forum.
I also have a 506 crore rupee claim.
Why have you initiated any proceedings?
No, because it was before appropriate forum as per
you initiate the proceedings, mister.
No, we will go to RERC. They will not. They will get it from here. Will not. Who's going to give it?
No. So far as we do not know what are your dues.
I just said so. Contempt court takes it into consideration.
Okay.
Can I just read that again? But very categorically it says.
Correct. Last paragraph. No?
Yes, last paragraph.
Correct. We have noted. Therefore, you initiate appropriate proceedings for recovery of that amount.
So it should not.
At present, we are concerned with the LPC.
It should not be piecemeal, my lord, is what my submission.
No. That is already.
Or in the alternative, my lord, if your lordship so thinks, if your lordship is expanding, my lord, then your lordship may give me an opportunity to come place it before this court.
For what?
For my claims of 506 crore rupees.
But then how can we say it's quite division bench order?
It's not different. It's a calculation of accounts on the basis of the payments made, my lord.
Mr. Try to appreciate. So far as that is concerned, in view of the last paragraph, we cannot say anything. We cannot do anything.
But same should apply for them also.
No. That is also.
Just because they come in MA in a disposed of, my lord, petition,
okay.
which has retained finality for
we will consider.
August.
Now you tell us what will be the interest, mister? What will the LPC according to you? We also may not saddle with the liability.
It has to be continuing. It will be 9% only.
You have paid this 9% interest up to 31/8/2020 or till the payment is made?
Till the payment.
2020.
March. March 23rd of March 22.
From the beginning till March.
That's why I said 3,000 crores, 2,900 odd crores.
3,000 or 300 or 3 crores makes then no difference to us.
Because the fact is that we have paid, we have complied. And complied till 23rd of March 22.
That is what exactly, Mr. we are telling.
Yes. We prepared a note, Lord, which will just one single page note will Lord help your lordship also to get the figures. Yeah.
That will also be taken away.
आ गया डिस्टर्ब था
No, no,
सुप्रीम
we
कोर्ट से
will,
ही
Mr. Counsel, you may be right. We will not keep the question with respect to LPC, correct, prior to 31 in 2020, because even division bench judgment contempt, correct, it is also kept open.
With that direction appropriate
Correct.
forum.
But
Your
why should,
lordship will decide
no,
upon
to have the parties ultimately, why should we leave it
ये
to
वाला
open
केस
to the
जैसे
for
ही
10 period
solve
also
होगा,
for
उसके
20
बाद
years you will
सोनी
be,
को बरी केस
why
होगा।
should that question be kept open?
This amount will increase.
Try to appreciate, we are telling in your favor, Counsel.
I quite see.
We are telling in your interest.
It is in the larger interest of the
That is what
public
exactly
also.
we are trying to tell
The
you.
larger interest of the public also. Lord, 31st August is the Lord judgment.
सही बात है।
Thereafter, my Lord,
We just want to restrict it from 31 day 2020 till the actual payment is made in 2022.
At the rate
मतलब
of SBR.
my respectful submission is we
Otherwise,
have paid out by
you can, we keep the matter after some time also. You apply the mind properly, correct, and tell them what is in their interest, correct. Otherwise, what will happen as per the division bench or the contempt court
ये
order,
इशू सुप्रीम कोर्ट
correct?
से ही है।
Everything will
वहाँ
be at
से
large,
इधर में
correct,
solve
from
होगा।
right from 2010 onwards, Mister. See, it will not be in the larger public interest. We will have the quietus and we will pass a final order. Correct that no liability prior to no LPC prior to the 31 in 2020.
let me take instructions and come.
Correct. Only on that point we consider that.
Because I don't want to say anything without a proper instruction.
No.
My lord,
That is what we are telling you.
3 minutes. Just come to 121. I heard your lordship loud and clear. I know what your lordship has said. My learned friend has said something. Just come to 121. I'll take 3 or 4 minutes. LPS was not there. I'll tell you why 8.3.5 was used. That my lord is rightly saying. Just see, Mr. Sundaram appeared for them. His contention at 121. Just give me a minute.
Mr. Then it will be very.
No,
in your para 65 to 68.
I'll tell you why it happened. Give me just 3. I should have said so earlier. My learned friend raised this point now, so I'm saying it. Just give me 3 or 4 minutes. I'll not take long. This case was about carrying cost. What happened was, my claim is, give me carrying cost at SBR. I should have said so sentence first. I thought it was obvious by the friend would say. My claim was, give me SBR for carrying cost also. Now there's no clause for carrying cost. So your lordships used 8.3.5 to apply that rate for carrying cost. And while applying it, your lordship said, however, to apply for carrying cost, where there is no clause, SBR plus 2% will be very high, so I apply ad hoc 9.
Not with respect to carrying cost.
Yes, just see this. 121. Give me 2 minutes. Just 2 minutes. 121. That's what is important.
Very difficult.
Mr. Sundaram says this.
65 to 68, very difficult.
I'm just pointing out that limit my lord. Your lord.
Still we are considering from 31 2020.
30th August onwards. That is in the period. My learned friend throws crores at your lordships. That is 2013 onwards.
I don't throw at lordship.
No, he's figure. See this figure is given here. But does he tell a lordship of 2013?
Okay, 120.
He has not paid. 2013 is the date. You are also saying 2010 is 2013 onwards. So
2010 is the agreement.
Today, Malas, if he doesn't pay this late payment, this quietest word your lordship used, whose interest is it? He's a discom, he'll pass it on to consumer. This period, this beta will keep ticking. It's better to put a quietest in his own interest, as the lordship says. Otherwise,
that is what he will get an instruction.
Now, just turn to 121. Just 2 minutes. I want to take on these 2 points. Your lordship may not have seen this because I didn't show it to you.
No. If this observation would not have been there, correct? In perhaps 65 to 68, correct?
I'm explaining it by saying
we would have kept everything open.
That's right. So your lordship is not hiving off at least 2 to 3 years and making it from 30th August. I hear my lord loud and clear. I am saying that this 9% figure came for carrying cost because I asked for SBR for carrying cost. Your lordship said we will take the analogy of 8.3.
No, that will be reviewed.
Because there is no clause. He himself said, this case is not about LPS. Just turn to 121. This case is about carrying cost only. That's the problem.
It is only specifically with respect to
Kindly see Mr.
payment charge.
Kindly see Mr. Sundaram at 121. This is their case.
Correct. Dispute was with you.
Unless the two periods are separate, there is no logic to apply the late payment surcharge, which is for the second period. Apply what? I said.
Correct.
Apply 8.3.5 to carrying cost for which there is no clause. Your Lordship said not that, but 9%. Mr. Sundaram said, don't apply it at all because LPS doesn't arise here. So, Manus, what has happened is it actually happened.
Mr. Dr. Singh, one please. Yes, please read 66 again. Very difficult, Mr.
Well, 66.
66 specifically with respect to the late payment charge.
Yes, late payment surcharge because I said.
Not it is said that the applicability of the carry cost with respect to late payment surcharge.
I'll tell you why. It is for the clause because there is no clause for carrying cost. So I utilized SBR to apply to carrying cost. Now see one more thing.
But it will be reviewing the order, Mr.
Well, anyway, I cannot say more than that. Your Lordship has suggested, according to me, a highly beneficial via media to them. But because I am not agreeing.
And we wanted to strike the balance between the two.
The matter, Maras, otherwise the meter runs against them onwards. Suppose Maras they don't.
That is what we
pay
have
the balance.
conveyed.
And your Lordship directs them to pay the balance after 10 years. Who's going to bear this 10 years cost?
That is what he will take the instruction.
Now, one more.
You advise them properly.
There is a judgment of your Lordship.
What is in their interest, what is in the larger public interest, Mr. Otherwise, if it is kept open from 2013 onwards, correct? And we do not know what will happen. No, you also don't know what will happen.
Absolutely, bro.
It will go to some forum. It will be decided after 10 years. He'll pay that thing after 10 years.
Correct. That is what exactly we are impressing upon them.
Just you should know this. Your Lordship decided in 2022 4 SCC 657 that the contractual rate of SBR for electricity matter 2022 4 SCC 657 paras 195 to 198. They're very evocative paras. That SBR is not high, is not arbitrary, and contractual.
So we are not on 8.3.5. Whatever was the 2% plus SPR, correct, from 31/8/2020 onwards till the actual payment was made.
I would say that.
And that too, what my learned friend is saying, this present judgment on para 202, specially stands distinguished by the subsequent judgment that is being referred to, and that judgment is to judge.
We are not on that.
On the SBR rate.
Yes.
You can impress upon them.
I will make an effort.
My learned friend can seek instruction, otherwise we've been mentioning this a lot. He can seek in that.
Or we'll pass our
No, it's not
subject to hearing you for 10 minutes. We are hearing.
I'm
saying tomorrow
on the reopening.
That is your Lordship.
Third in part.
Yes, possible Lordships can give balance.
Having got the learned counsel respective parties at length, we are prima facie of the opinion that applicants shall be entitled to the late payment charge as per clause 8.5.3 at least from
8.3.5.
8.3.5 at least from 31/8/2020 till the actual payment was made pursuant to the order passed by this court in contempt proceedings. If that is considered, we have the opinion that it will be in the larger public, it may be in the larger public interest. And the original appellant, that Jaipur Vidyut Vitran Nigam Limited may avoid further litigation with respect to late payment charge from 2013 onwards till 31/8/2020 over and above the 9% already paid pursuant to the earlier judgment and order
जस्ट
passed
इसके
by
बाद
this court
स्टार्ट होगा, इसका लास्ट ही है
in the main civil appeal.
और हमें लगता है कि
So
हाँ,
loaded
कोई वकील
AAC.
है तभी इतना सुना गया.
Jain है?
Yeah, Jayan sir.
Jain Sood. Jain Sood. Loaded AAC. Prays for some time to get the further instruction. Full point. Put upon which date?
Any date on reopening.
We asked the
And
earliest
Lordship
possible
has fixed the date. No.
So we had difficulty that we, your Lordship, have a heavy crowded board today here.
Jharkhand.
No, I know Lorships can take it up tomorrow, day after. I can only make a request.
Day after tomorrow bench is not. And
In January, the earliest date.
I'm not aware.
Whatever the earliest date, Your Lordship.
Non-sitting कौन सी है?
हाँ बता दी
देख लेते non-sitting. कभी non-sitting. Late payment surcharge.
So give me the earliest available Your Lordship's calendar in January. What can I?
हाँ January को. 10 तो CB है.
10th is the constitution.
CB.
बस
Your
बस
Lordship is part of this.
तो 6
अरे हटो भाई
6 January.
6 January. Obliged.
6 January कौन से?
Could be after.
January.
I'll leave it to Lordship.
हमें भी
January.
आसान कमेंट करना दूसरा
Let us see if we will see.
Very, very deeply obliged.
Yes. Jharkhand.
झारखंड अब स्टार्ट हो गया झारखंड का महायुद्ध। बाला कुमार जी दिख रहे हैं, अजीत कुमार सिन्हा जी दिख रहे हैं। मेन कप्तान कहाँ रहे हैं?
Yes. We'll go one after the other.
Why it is by whom we do not know.
That's my lord.
पल्लव सिसोदिया नाम लिखा है.
I have
प्लीज एक बार शेयर कर दे सभी लोग, ठीक है?
आपका नाम नहीं लिखा. Your name.
और 100+ लाइक करिए, कम से कम 88 लाइक है मात्र।
So if you give us copies only, then only we can respond.
बालाजी दिख रहे हैं, अजीत कुमार सिन्हा जी दिख रहे हैं, कपिल सिब्बल जी कहाँ
Another third one
रहे
is for by whom. नवनीति प्रसाद.
हैं? अब आ गया।
This is अजीत कुमार सिन्हा.
अब ध्यान पूर्वक सुनिएगा आप लोग, थोड़ा सा शांत हो जा रहे हैं।
This is by whom. Suggestions to this honorable.
By myself, on behalf, I'll just put the
नाम लिख के देने के
तो बोलूं. The status of the applicant Sheikh is who has given.
Yes, madam. I will. Yes, sir.
अजय कुमार जी अब चले जाइए।
Now,
We are beginning there.
who are on one side and who are on other side?
We don't know which side we are on. What will go start with the note because Lord, there are three issues
The
now.
petition is filed by me, my lord. If I may be not allowed to, my lord, open.
Now you are satisfied?
So, my lord, I have three things to point out, my lord, and then my lord, I will just. So, a compliance report has been filed yesterday night,
Compliance report लायो.
which is the affidavit dated 13/12/2022.
13.
13/12/2022,
Sometimes you see,
which is yesterday.
to show some grace and to save the appointment. This is the problem. If everything would have set aside, then no difficulty.
Please.
Compliance affidavit session को हटा देते हैं.
This is the affidavit filed late last night, my lord, is what I understand.
This is by Pallavi.
Yes. So it is formed by one Mr. Ravi Kumar,
secretary.
secretary, and it runs into 4 pages of affidavit and then annexures.
Given to the board.
So may I? The total number of pages in this is 37. It runs into 37 pages.
Given to the board.
Yes.
My lord, I want to first place, my lord, 2 things, my lord. The lordship will kindly come to paragraph 4. Further, the order dated 2/12/2022 passed by this honorable court also directed the state government to prepare a list of original writ petitioners who had approached the High Court and may be appointed, adjusted in the concerned scheduled and non-scheduled district. Accordingly, a status report was filed by the state government on 8/12/2022, which is what your lordship were seeing earlier, what your lordship had in your lordship's hand. Inter alia, placing on record details of original writ petitioners before the High Court from amongst the list received from the contempt petitioner herein. Simultaneously, the Jharkhand Staff Selection Commission has issued a list of 245 original writ petitioners as per their merit list for verification of their documents. The Jharkhand Staff Selection Commission is likely to take a period of 1 month for the document verification and recommendation in respect of these 245 candidates who were the original writ petitioners. Thereafter, the state government would require a period of 1 month for completing the formalities related to their appointment. Therefore, the entire process for appointment of these 245 original writ petitioners shall be completed in a time period of 2 months. Apart from the above, para 5 number, apart from the above 245 original writ petitioners, the state government has identified the names of 143 writ petitioners who have filed the writ petition before the impugned judgment in the Soni Kumari versus State of Jharkhand was rendered by the Honorable High Court of Jharkhand at Ranchi, and therefore these writ petitions were disposed of relying on this Honorable Court judgment, while orders dated 30/8/22, 31/8/22, the Lordship judgment is of 2nd August 22 and 17/11. It is submitted that the state government will take steps to complete the process of verification of candidates as per the orders of this Honorable Court on 2/12/22. Copy of the list is enclosed here. Now, my lord, 3 things I want to wish to bring to Lordship notice, my lord, with the Lordship's leave. If your Lordship take the contempt petition, and if your Lordship will kindly come to page number 123 in your Lordship's order, in your Lordship judgment rather, but I'm so sorry. Your Lordship will just kindly read this para 26.3 with me. Your Lordships have the contempt petition?
Please read it.
Yes. In the present case, impugned notification order is of the year 2016. The TGT recruitment process was initiated while advertisement dated 28/12/16 as modified on 4/2/17, and the same came to be challenged during the pendency of the recruitment process in the year 2017 itself. It is also required to be noted that by order dated 21/2/2019, the Division Bench of the High Court directed that notice be published in the daily newspapers having wide circulation about the institution of the writ petition so that person interested may intervene in the writ petition. Pursuant to such notice, several interlocutory applications, intervener applications came to be filed, which came to be allowed by the High Court. Thereafter, by order dated 18/9/2019, taking into consideration the question of constitutional importance, matter was referred to full bench. So, my lord, why I wanted to bring to your Lordship's notice this is that the number that we had given was 216 in our contempt petition. The order asking for publication in the newspaper, I have got a copy if your Lordship would like to have a look at it. This was published. Thereafter, when these matters who filed after this order of the High Court, my lord, the High Court passed an order on, my lord, the bench of the Chief Justice after the reference had been made, put up after disposal of the matter which is being heard analogous to other writ petition by a full bench. That order, my lord, your Lordship may see, that was on 7th January 2020. I am just passing on that order, my lord. Lordship Court must have been. Just take one copy. 7th January 2020, those number of writ petitions, my lord, which are marked there. What is on this? What you have given? I'm sorry, my lord. I don't have that paper. Page 10, my lord. Page 10 of the what we have been handed over. Kindly see that. This is an order of 7th January 2020.
What is your submission?
No, I am only pointing out that these number of writ petitions were not taken up with the full bench. Thereafter, my lord, another order judgment was passed on 30/8/2022 by the Honorable High Court. After your Lordship's judgment here on 31st August, my lord, which is at page number 12, and your Lordship will come straight away to page 28. Page 12. At page, my lord, 28 30, sorry, page 30,
Page 29. Page
3031. 3031 is the order, my lord, passed on, my lord, 31/8/2022, after your lordship judgment, allowing all these writ petitions were prior in point of time pending disposal of full bench. So I am only wanting to bring to your lordship's notice this, that I had identified those writ petitioners who were with me, 216. The other, my lord, the compliance report shows in para 5 that they have identified 143 more writ petitioners. So those are because of these orders.
Correct, we got your point.
Yes, that's what. And so far as I am concerned, my lord, I have compliance has been done. So far, because we are put in the name of this first paragraph 4. Para 4, our names are all there, 216 which we had given, and their matters have been sent for verification.
At present,
so far as my contempt is concerned,
216 plus 100 for the
yes.
13 persons cases are under consideration by them.
245 plus 143. They have identified 245. We had identified 216.
245 plus
143. That becomes 388.
So they are considering the case of those persons.
Yes.
Who were actually not appointed.
So they were not appointed.
And
they were the petitioner not appointed. So as far as I am concerned, my lord, today my name is there and my name
your
is
case
also
will be considered on merits.
Yes. And we are, so therefore, my lord, so far as my contempt petition is concerned, your lordship may only direct, my lord, that within 2 months, as they have said, the entire process should be over qua me, my lord.
What is your contempt petition number?
The contempt petition number is 612 of 2022.
Okay.
That is my contempt petition. I'm very obliged for that hearing.
Contempt by Sonu Kumari.
Contempt by Sonu Kumari.
Soni Kumar.
Soni Kumari. Sorry. Soni Kumari, the original first petitioner.
Yes, Mr. Diwan.
I'm very obliged, Lord.
We'll start from this.
Okay, I'll just be very brief.
Who are you, Mr.?
Yes, I'm an intervener, and I'm an intervener in my IA is 190152 of 2022. I believe a note or short, just one pager has been handed over to the court just now. The caption is IA number 190152 of 2022. Just a one pager.
Okay.
I've just handed over the same sheet again. Great. May I just state my point? And I'll just go through the note, but let me just state my point. I was before the High Court as a respondent, intervener, pursuant to what Mr. Ranjit Kumar just placed. There was an advertisement in public notice. I pleaded myself, so I was before the High Court. I was happy with the impugned judgment because it did not affect me the judgment which was impugned in this court, the full bench judgment, because I had applied in a post for a non-scheduled district. So I'm in the non-scheduled district category, and being non-scheduled, it was not the subject matter of the full bench decision at all. It came up here, your lordship's final judgment. I was absolutely satisfied with that, no grievance or concern with that at all. My problem began with that 2nd December order which was passed by this court. And I'll just come to that in a moment. So can I just now run through my 7 points and then I'll just take you to the 2nd December order. Applicant interveners had applied for a post of non-scheduled district areas. Each of the applicants, pursuant to an advertisement and public notice issued in view of the directions by the Honorable Jharkhand High Court, impleaded themselves as party respondents to the proceedings, which culminated in the full bench judgment. Intervener number 1 was impleaded as at number 2362. Intervener number 2 was 583 and intervener number 3 as respondent 31 before the High Court. The applicants have no grievance whatsoever to the judgment of the full bench of the Honorable High Court. The full bench in its judgment in para 63 at page 80 of my IA notes that the appointments made in non-scheduled districts were not challenged in the writ petitions. Further, in para 66, the full bench clarified that the selection process in the non-scheduled areas were never stayed. Additionally, the applicants have no grievance with the judgment of this Honorable Court dated 2nd August 2022, affirming the judgment of the full bench. Applicants are affected by the order of 2nd December 2022 of this Honorable Court as interpreted by the state of Jharkhand. Since the applicants are high on the...
Let us see that order.
Yes, now that your Lordship will find, if your Lordship, if the Courtmaster can hand over my IA 19052, you will find that order at page 191. It may also be in the content.
The beginning it is there.
We want ready, Mr.
If your Lordship has that IA, you will find that that order of 2nd of December begins at page 189. The relevant portion is at page 191.
Please read.
Your Lordships have it?
Yes.
Yes. So should I just place this order before the court?
Yes.
I'll just place it and then go back to my note. Let the state prepare a merit list of those candidates who are actually appointed both in the scheduled area and non-scheduled area. Thereafter, whoever a candidate in the non-scheduled area is found to be more meritorious than the last candidate in the scheduled area of which he has given option, then that candidate in the non-scheduled area be adjusted in the concerned scheduled area as per his merits, and the last candidate in that scheduled area have to be reshuffled and adjusted in another district among those who are already appointed. Similarly, with respect to those original writ petitioners who approached the High Court, their merit list also be prepared by the state government, and they may accordingly be appointed and or adjusted in the concerned non-scheduled or scheduled district as per the merits. However, it is specifically observed that except those who did not approach the High Court, the benefit of this order shall not be given to them. List on 9th of December 2022. Now I'll just go back to my note and then I'll just make my short submissions. So I said in para 4 that the applicants are affected by the 2nd December 2022 order. Since the appellants are high on the merit list of the non-scheduled areas, they expected to receive appointment letters amongst the 17,784 posts advertised. Relying on the order of 2nd December 2022 passed by this Honorable Court, Jharkhand is considering appointments to only, now this is my first problem, to only original writ petitioners before the High Court. Despite the present applicants being party respondents / interveners before the High Court, they are excluded from the scope of consideration. So this is going to be one issue. Para 7. Further, the order dated 2nd December 2022 of this Honorable Court, referring to the appointments already made, the state of Jharkhand is excluding the present applicants from consideration. The state did not issue appointment letters to the applicant, even though there was no embargo on making appointments for non-scheduled areas. And now on the basis of their own inaction, they are attempting to exclude the candidates who are not actually appointed. Now, may I just indicate what has happened? Since I was applying for a non-scheduled area, I was not directly concerned with either the full bench judgment or your Lordship's judgment because there the focus was very clear. Now, in that backdrop, I was not affected adversely. However, I was before the court, I had implemented myself as a party respondent. Now, after your Lordship affirmed the judgment and passed those operative...
Why you were not appointed?
Yes, now, very important. What the state of Jharkhand did or considered was, even though there was an interim order and even though the High Court full bench notes there is no embargo whatsoever, they stayed their hands. They did not make any appointment in the non-scheduled areas for all these years. So they granted an injunction to themselves.
Yes.
So therefore, all these 17,000 and odd posts remained vacant, and now they are seeking to make an appointment pursuant to your Lordship's final judgment, over which I have no problem. But now the problem, now I'm just articulating my issue because of the 2nd December order. The first concept in the second line is, were actually appointed. Now, I was not actually appointed because there were no appointments made in the non-scheduled areas at all. So all of us who had applied for non-scheduled, who are not concerned with this controversy, are finding this observation limiting. So I'll make a suggestion also. So this is the first point. Let the state prepare a merit list of those candidates who are actually appointed I would consider your lordships to add the words or appropriate phraseology or entitled to be appointed. So either appointed or entitled to be appointed. I am entitled to be appointed because I'm very high on the merit list for the non-scheduled area. This is one problem, one issue, sorry. Then please see the last part of that same sentence, that same paragraph. You have to be reshuffled and adjusted to another district among those who are already appointed. I am again suggesting over there also, please use the expression already appointed or entitled to be appointed, because then I will not have this problem at all, because it covers thousands of us across the state who never receive, who are not even the subject matter of the main petition. Now please see the next paragraph.
Mr. Shah,
Yes, I'm sorry.
The only difficulty, so far as this is concerned,
Yeah.
we may consider on the case, correct, with respect to those who were not appointed for not fault of them.
Yes, yes.
Correct?
Yes.
We may consider.
That's right.
But to reshuffle everything, correct?
No, but there's no
We'll ask-
shuffling.
we'll-
Yes, I understand. There were no appointments made in the non-scheduled areas.
Your case can, subject to asking them.
Yes.
Your case can be considered,
Right.
correct? Or not, because your case was a non-scheduled area.
Right, and very high up. I mean, that's what I claim.
They did not make the happen because of the pending litigation.
Yeah, for the scheduled area.
Correct. We have in the main judgment also we have noted that
Yes,
aspect
yes,
also.
yes. Agreed.
That at one point of by distinct recollect, it was observed that there was no order with respect
Para
to
66 of the full bench also notes that.
it is specifically
Correct,
mentioned.
correct.
We'll ask them
Yes.
why the appointments were not made.
Correct.
If you are entitled to correct, but it may not be.
Yes.
Correct. You can be appointed.
Yes.
Subject to hearing other side.
Of course.
If the posts have remained vacant.
Yes.
Correct.
So today,
Then
yeah.
on the vacant post.
Yes.
In the non-scheduled area.
Yes.
Subject to this, your case can be considered for appointment.
Yes, I'm very grateful.
But not that because to appoint you,
Right.
somebody already appointed, correct, is to be.
No, so now may I just one small point which I'm on this aspect.
You be satisfied with the appointments.
Yes, I agree. So your lordships, when you put a question to the state, please also ask them, out of the 17,000 seats which I have mentioned, how many were 17,784? How many were vacant on the date of your lordship's judgment? That will provide a benchmark, because I am told even to this day there are 9,000 which are vacant.
We'll consider.
Now the second issue is on the next paragraph. So I'll just make a suggestion. Similarly, with respect to the original writ petitioners who approached the High Court. Now your lordship recalls we were all impleaded as respondents. So we were before the High Court.
No, this is with respect to, this is with respect to those,
Yes.
correct, who were already appointed, correct, or they were not appointed in scheduled area because of their bar.
Right.
So, these observations are with respect to them.
Yeah.
These observations are not with respect to those, correct, who applied in the non-scheduled area.
Absolutely right. Absolutely right. But what is the state doing? Because now they filed a compliance report. They are not interpreting it in that manner. That is exactly how we understood it.
We consider it.
Yes. So that last part also, which your lordship is clear. This paragraph is really with regard to the scheduled areas. That's second. And similarly, I think the third paragraph of the order also goes with the earlier paragraph. However, it is specifically observed that except those who did not approach the High Court, the benefit of this order shall not be given to them. I am only suggesting I was before the High Court as a impleaded respondent. So for all, obviously the High Court didn't want 10,000 writ petitions.
All are selling.
Yes.
But I was
This is
just,
very grateful. This is my point.
Lord, I want to just complete, Lord,
Don't raise the voice. Huh?
Lord, may I just supplement
Like
what,
punishment will be heard subsequently.
Lord, may I just supplement what Mr.
Yeah,
Deepak?
we have said from this.
Lord, let us, I may kindly take 1 minute. After, Lord, only 30 seconds.
Which one, Navniti? Yes.
Lord, 30 seconds.
No counsel.
Your Lordship may have my notes, it's a 2-page note.
Trying to find out the way.
Now,
1 minute. One minute. Which is your.
Lordship will see the notes on the right hand top.
Harapan, we are let us first of all.
It is in contempt petition 707, item number 13.1. Right hand top, Your Lordship sees. or on the page 3, my name is there.
V. Mohana. Vallabh Sisodia.
Saroj Kumar Mato, the name on top.
Saroj Kumar. Yes.
Your Lordship. Now, the petitioners before your Lordships have filed this contempt.
Not read it.
Your Lordship.
See
The petitioners are for scheduled area. They had been selected and empaneled. Their document verification was going on for appointment. Now, some of them were appointed. Some of them were waiting their document verification when the writ petitions were filed. The process of appointment carried on till a stay was granted by the High Court. And that is how some of us got appointed. Some of us, even after document verification was...
You got the appointment in scheduled area.
Your Lordship, we were empaneled for appointment in scheduled area.
Correct. So far as those persons who were appointed in scheduled area, their services were as such required to be terminated. But we protected the services of those who were already appointed.
Your Lordship.
Now, so the question was only with respect to non-scheduled area and the scheduled area. Correct. Those who applied, correct, for for scheduled area, correct, but they were not considered because of the notification and the bar under there. So that is the only point which is required.
Now,
so your case stands on a different footing, Mr.
Your Lordship, the state is taking the plea that as we were not the writ petitioners, we were not required to file a writ because we had been selected.
Then you file your independent proceedings, Mr. We are not concerned with that.
We were already selected. It was
that was not the controversy before the court.
We were not selected. We were selected. Therefore, we were not to file a writ petition.
Correct, but then you initiate the proceedings. We were entitled to. Sorry, we will not consider your case.
We were made respondents in the writ petition.
Okay.
And
we protected the service. We protect the service of only those persons who were appointed in scheduled area, correct? So that they may not have to go home.
Your Lordship, we were in the merit list.
Maybe, Mr. But you were not appointed at all, no?
No, we were selected. We were in the select list already.
We were not appointed, no? In the scheduled areas.
Your Lordship, our appointment process was on.
We will not say anything so far. We will not clarify anything so far as those persons are.
What they are doing is they are not even considering us now. When your Lordships have directed.
When you file appropriate proceedings independent before the High Court, that will be considered. We do not.
The persons who are being considered are below us in the merit. They are being considered.
Then you point out to the High Court that the persons who are having less marks than me are appointed, so please appoint me.
No, correct? Your Lordships have said that they will take up people on the last from the cutoff. Now we are way above the cutoff.
Okay, we are not on that. We are vis-a-vis those persons who are to be transferred to the scheduled area. We are not going to expand the scope of the writ petition at all.
No, Your Lordship, in these in 8 districts of scheduled area, no appointments have been done at all.
Okay.
Now, as per the merit list, all we are saying is consider the merit list. We can't be ousted.
We cannot reopen everything.
Your Lordship, because the merit list is already with them, they had made the merit list. Now they can't exclude the meritorious people and take people.
You initiate appropriate proceedings. We are not restraining you, counsel.
They are taking your Lordship's observation that as you are not the writ petitioner and as you have got no relief from the court, you will not be considered.
We will not reopen. We will not expand the scope of that, Mr. Just wait up.
Please, my lord. My note is also there, my lord. I am similarly placed with that of, in fact, one step further is that after the High Court judgment was passed and your Lordships rightly noticed the para 66, I am the toppers, I am representing few toppers in the non-scheduled area, my lord, for the subject of Sanskrit, my lord. Their process was also completed, my lord. Selection was...
Okay, then you are the same.
The same. Only thing is, I also made an application before your Lordships, just one second. I also made an application before this honorable court, your Lordship may recall, not to consider this while passing the judgment in that. Your Lordships were considering only the scheduled districts, so I was requesting that time also my appointment may be made. Process was complete, not, but they never made, they put their hands tight, only because the court was this.
Yes, Mr.
I'm only praying that.
Lordship, I kindly take my note.
I'm also in same footing.
Okay, then we will not hear all, Mr.
Lordship, I kindly take my note.
We will consider it.
Lordship, I kindly take my note.
Yes, sir, we are ready.
Now, Lord, first paragraph I have pointed out.
Who are you?
Lord, I am the interveners who are also before the High Court and my lord, before your lordship.
Who are you? We know, Mr.
I, not
What's your status?
Lord, we were not given employment, though not we are in the state merit list and the district wise merit list.
You applied in the non-scheduled area?
Non-scheduled area.
Like Miss Mona?
Like Mr. Diwan. Like Mr. Diwan.
Okay,
So,
1, 2, 3.
Yes. Now, Lord, there are three.
Okay, we will consider it.
No, now, Lord, three scenarios which emerge. Lord, I'll just read three sentences from my note. Kindly see, Lord, first part of note. I've given the background of the stay order, the misinterpretation, etc. Now, Lord, the first. Lordship may come to bottom of my first note. One straightforward option is to complete the recruitment process on the basis of state-wise merit list. This ought to be done irrespective of who goes out or comes in, except on merit. That's suggestion one. Second is not, the Lordship turns the page. Another option is to protect the incumbents already in employment. Though it was expressly negatived in the final judgment of this court at Pidgeot Swens. Even after accommodating those already in employment, more than half the vacancies shall remain, for which selection process on the basis of state-wise merit must be.
No, we do not follow that. The incumbents already in employment means?
Not the appointments which were already made, and your lordship said that they would not be disturbed.
Correct, we have already stated.
Fair enough.
Our order is very clear.
Yes. So, Lord, out of 17,784, even half the vacancies are not filled. That process was going on. Yes. So, for that.
It was only with respect to non-scheduled area.
Yes. Now, Lord, both. Everybody. Throughout the state. Because now, as per your lordship's judgment, there has to be a state-wise merit. Now, state-wise merit may mean that some people who are already in employment, but their lowering merit may go out. Now, if that option is out, then the other option is that keeping them also, still not more than half the vacancies are to be filled.
That we are considering.
Yes. Now, the third is important, Lord. By the order of 212 is misinterpreted now to confine selection process to only the original writ petition before High Court. This gives a fresh employment to about 388 persons, as Mr. Kumar has pointed out. Majority of whom are not in merit, either in the district-wise merit or the state-wise merit. This compounds injustice to candidates much higher in merit who have no claim to approved and are otherwise content with the main judgment of this honorable. Assuming the original writ petitions are to be given employment regardless of merit, more than half the vacancies shall still remain for its selection process on the basis of state-wise merit. Now, but the persons whom Mr. Kumar represents, even on the new merit, state-wise merit, they don't come. Only decimal is the merit in their favor.
And they have succeeded before the High Court.
Fair enough. I don't.
They approach the High Court.
No, I don't.
Succeeded. And they will not get the benefit on
Please,
they were not meritorious, Mr. You never approach the High Court.
Lord, we have no case. Lord, we are in merit, either merit.
Your appointments were not made.
Fair enough.
Anyway, we will take care of Mr.
So even if 388 are accommodated, even then not more than half the vacancy.
Don't repeat, Council.
Let me just point out one more fact. After your lordship's order of 2nd December, the process was going on. One line order that process roka jata hai. That should be resumed. Because that would not take. I am also in the security.
May I start with this seconds one? Now, I appear for people whose advertisement of was 2017, not the subject matter. The post were LDC, Panchayat Secretary, stenographers and others. Total post advertised was
not part of this advertisement.
My learned friend will again interrupt. That's the problem. We never interrupted. Let me say in a motion, Milos, otherwise I'll lose my control. I'm not confident like him. Anyway, 4950 is the total seat.
You will lose your control or confidence?
I'm losing both. The flow comes.
We are worried about losing the control.
Then it will be very difficult.
Very difficult.
I know that. So now I am maintaining my control and cool and addressing the Honorable Court.
Don't interrupt, Mr. Kumar.
I am so grateful. Now, 4950 was the seats advertised in 2017. That is not the subject matter.
What is the
The posts are stenographer, LDC, and Panchayat Secretary. My lords have recorded the argument in civil appeal number 4043 in paragraph 2. 4043, my lords have recorded the argument. State has moved an application supporting us. That is item number 5. My lords may take it. I will not harp more than that. That permit me to declare the result. Everything was over. Not a single has been appointed. So there is no dispute on that. That is my humble submission. State MA is 38161 of 22.
MA number?
Eight second, yeah. 38161 of 22.
Sorry, 38.
I'm sorry, plus 38161 of 22.
38161.
Yes, plus of 22 by the state of Jharkhand. And para 8, if my lords may just permit me to take that copy, because that will have a bearing on our matters, and I'll keep quiet after that. I have moved also an application, but the state supported us.
What is your IA?
Milos, my IA is, I'll just give that number, Milos, 36802 of 22. And the item is 13.3 in today's board, Milos.
Okay, we'll consider.
Milos, just one paragraph I'll show and state. May I? That is, Milos may make a note of it. State application, page 8, para E, and prayer number. Yes, she is there. She is also saying that. May I pass on the copies? Copy. This has nothing to do with that, and not a single post has been filled. 4,000, and there are only 3,880.
Okay.
Milos may come.
Just may not have any objection with respect to other posts. You are concerned with the teachers.
They are concerned with teachers. Me and Bala.
We clarify.
Yes, only to that. And now the state has moved. Just permit me to read the prayer and then I'll sit down.
Why are you coming? We have not passed any order on LDC.
That is why they have sought permission, Milos.
Of what permission?
But my lords have dealt with it in para 2 and not passed the direction. At page 8. That will clarify. The same thing which I said, Milos, it is recorded in there.
Yes, para 8.
Milos, at the top, para E. Running page 8, Milos. That para 20 of the judgment, Milos, got it?
Yes.
This Honorable Court refers to Civil Appeal number 4043 of 22 and relates to advertisement number of 1 of and 2 of 2017. The said advertisement was floated for appointment on the post of lower division clerk, Panchayat Secretary, district level post, lower division clerk, state stenographer, state level. However, there is no reference to this civil appeal in the operative part of the judgment. Then next page, Milos, they have prayed for issuing direction so that they can advance.
Why don't you file the application in 4043?
Milos, that's my appeal. Because in the High Court, if my lords may recall.
That is what we are saying. If there was no, then you should have filed an application in 4043.
We filed it. We have filed it.
Your IA is in 4043?
Yes.
Okay.
I'm sorry, Milos, I was not clear. That is 13.3 listed today. Same prayer which the state has sought, we are also seeking the same prayer as diary number 368.
But their application is in 4039.
No, Milos. In fact, if my lords may see the prayer, other clarification including mine, for teachers also. If my lords may see, page 8 I was showing below. At the top, Civil Appeal number 403, para E. My lords got it? Running page 8 of State Affidavit. At the top. Civil Appeal number 4043 of 2022.
See?
My lords got it? Running page 8, para E of the state application. At the top, Milos, in para 20, Civil Appeal number 4043, in which I have also moved.
Correct.
And then the prayer is at next page, Roman 5, page 10. That it should be extended to advertisement number 1 and 2 of 2017 at the bottom, Milos, on page 10.
Para 5.
Yeah, I'm great. Roman 5. The ratio of the advertisement number so and so may be extended to advertisement. That is their prayer. Only thing what happened, they wanted that tomorrow I may not be, let us seek a permission. Same prayer we have made it in our application also, and not a single C. And the entire dispute is of teachers. Mine is already ready, Milos. Even the documents have been verified. They had to declare. They have prepared the list. They have to declare.
But what about the scheduled area and non-scheduled area?
Because there is that is what they have to give the final list on based on merits.
So they have to consider, no?
That is
They cannot restrict the scheduled area of candidate only.
They are not restricting. Para 8, Para E itself says, they clarify that it is a bottom line, Milos. Para E, last 4 lines.
Yes.
Accordingly, Milos, if my lords may see.
Yes.
Accordingly, the preparation of a state-wise, the same thing. Category-wise, service-wise, merit list followed by allocation of district in the district cadre through counselling in order of merit may be applied. Also in advertisement, that is our advertisement. So same thing, they are praying for it. So,
but not that it should be restricted only to the candidate.
No.
Scheduled area only.
They have not even one has been appointed. 4,000 seats are available, 3,000 something. They know that. I am relying upon the state and they are seeking permission to implement it. I am so grateful.
My application is similar. I am sailing with Mr. Ajit Sinha, my lord.
So am I.
My MA is 38389 of 2022.
1 minute. What is your number?
Yes, MA 38389
2020.
of 2022.
Okay, we'll consider.
In civil appeal 4043.
We'll consider.
Yes, my lord. Same.
Lord, Mary, 19684.
Your is MA number 38389.
Yes, my lord. Yes.
Then 1.
Yes, my lord. And the application is only in relation to this advertisement 2017, which is actually, my lord, the same advertisement.
Mr. Das, what is your number?
My number is 196841.
Sorry, 1
196841
of
of 2022.
IA or MA?
It's an IA in the main matter itself. In petition, we'll hand over notes also to this.
What? Any other belonging to that
Deeply obliged for the entire.
Any other with respect to the 2007?
No. We only 3.
Let us one by one pass an order.
Please, one.
We are left. 2 of us.
We are concerned with those at present the LDC and others, not teachers.
Yeah, correct.
Let one be over.
All right.
DK, MA number 38161 of 2022 with IA number 36802 of 2022 in CA number 4043 of 2022 with MA number 38389 of 2022 with IA number 196841 of 2022.
41 and 46. 41 and 46.
41 and 46. 196846. These applications are with respect to the appointment on the post of 1. Lower divisional clerks into bracket collected cadre bracket complete dash district level post, 2. Panchayat secretary dash district level post, 3. Lower divisional clerks dash state level post, 4. State stenographer dash state level post for which the advertisement number 1 and 2 of 2017 were issued. Full point. The litigations in the earlier, the dispute in the other matters was with respect to the appointment in the appointment of teachers in the scheduled and non-scheduled area. Full point. Though the ratio, what is the main number? Though the decision of this got
Civil appeal number 404.
No, in the main, the teachers matter 4039.
4050.
4044 is the main judgment which was rendered in Satyajit Kumar versus
4044.
4044 and another connected appeals. Very many connected appeals.
Though the decision. The yield order was 4038.
Milos,
4038.
4038 of 20.
and connected.
Though the decision of this civil appeal number 4038 of
2022 and connected appeals was with respect to the teachers. It is clarified that the said ratio shall be applicable with respect to the appointments for the posts in question, namely so and so, so and so, so and so, 1, 2, 3, 4. And therefore it is clarified that the state has to prepare the state-wise, category-wise, service-wise merit list followed by allocation of districts for post in the district cadre through counseling in order of merit for the post advertised by the advertised number 1 and 2 of 2017, and the process of appointment be made in accordance with law on his own merits. Full point. However, the earlier bar, with respect to the scheduled area candidates only, shall not be applied. Full point. With this, therefore there shall not be any impediment in proceeding further with the recruitment appointment pursuant to the aforesaid advertisements.
Number 1 and 2 of 2000.
Advertisement. With this, present applications stand disposed of.
We can take a lot of petition and contempt petitions are filed in high courts. They should not come here to you, your lordship, thinking you have not heard us. No, I'm just informing the honorable court that you are only few people.
Our shoulders are very big.
So why don't you just protect the state, saying all the petition, contempt petition pending in the high court are disposed?
No, we cannot.
Only one thing, Milos, I have given 2 months time, Milos. They have also prayed for 2 months time. Within a period of 2 months.
Yes, and yes, sir.
So the writ petition may be given quietus.
Okay, now.
Having non-citizen area, my lord. My name is in the list, my lord.
Non-citizen area we consider.
Yes, my lord. My name is in the list, my lord. Your lordship, 1 minute. On 3/11/2020.
पंचायत सचिव के जितने कैंडिडेट्स हैं आप सभी को बधाई.
I'm not repeating, your lordship, I'm just pointing.
We are already, so far as those persons who are not appointed in scheduled area, we will not pass. It will be open for you, correct?
Document verification was to be done.
We are not on you council. And then Mr. Vikas Singh said that we are losing the. He doesn't understand what is our procedure. He is saying in the open for his own purpose. Consider our difficulty also, Mr.
No, I said so, Lord, your lordship. I'm forgetting I said so that we see your lordship sometimes getting impatient, but we don't make a protest. And Mr. Sibal in the morning only said that your lordships are keen, even though your lordship may hear only one at a time.
I am the tiger.
Your lordship, the only clarification we had sought was that those who have already been selected, they can't be ignored.
Go and file a writ petition before the High Court and your cases on merits will be considered, counsel. We will not say anything.
Because after your lordship...
What is your IA? You tell us IA. What is your IA number?
Your lordship, we have filed the contempt, your lordship, 707. Your lordship, because after your lordship passes an order, the High Court is not going to modify that.
No.
All we have...
Your contempt is 707.
Your lordship.
Huh?
Now once
these are the persons. We are dismissing your contempt. Sorry, counsel. Contempt numbers 707 of 2022. So far as the petitioners are concerned, they are the persons who as such were never appointed in the scheduled areas.
We were in the select list already.
Though according to the petitioners, they were in the select list. Full point. This is the contempt petition. Full point. The dispute was with respect to the claim between the candidates belonging to the non-scheduled area and the scheduled area. Full point. we see no reason to entertain the present contempt petition. However, it is observed. Hence, present contempt petition stand dismissed. However, it is observed that if the petitioners are having any claiming the right independently, they may approach the High Court and their claim public petitions be considered in accordance with law and on their own merits. With this, present contempt petitions stand dismissed.
Your Lordship, may
That's
say
one
one
last counsel.
Your Lordship,
My number, my IN number is 191417. This is my Ravin Bharti.
Who are you?
We are in the scheduled area. We are in the scheduled area. Selected candidate will not.
Like which Prasad?
Yeah, like him. Now,
What is the IN number? What is the IN number?
IN number is 191417, but I want to say something. I-191417 of 2022. Now, my lord, the direction was given by your lordships on 2nd of August 2022 said that we prepare a merit list both for scheduled and non-scheduled.
Sir, counsel, that was only for the purpose of adjusting those persons with the non-scheduled area to account in the scheduled area.
We have not agreed with that. Now, subsequently, when the order was passed by your lordships on 2/12, what your lordship said that if you are not filed a petition before the High Court, then it will not be considered. Now, what I have said is not because we are.
That is an interim order, counsel. We are still considering the final order. I vacate that 2/12 order.
Only that particular portion will not be vacated, but the state in any case considered. Petition before the High Court. I was selected. Now, because of this particular observation which has come, if you are not before the High Court, that
will pass the same order which is possible. You can initiate appropriate proceeding.
I am asking myself a question.
Main judgment that was not with respect to your non-appointment at all.
Directed in para 20 and I have quoted, just kindly have a look at that para. I have quoted in my, just read my logic para.
We don't want to expand the scope of our original field.
It is within the directions which are given by lordships in the main judgment. In
डाटा कनेक्शन प्रॉब्लम है। एक सेकंड के अंदर हो जा रहा है, टेंशन मत लीजिए। हॉटस्पॉट ऑफ हो गया था।
Your Lordship's main judgment
That is
cover.
already circulated in the office note.
ये डायरी नंबर ने वो भी वो उसका डिस्पोज किया ना, उसके साथ में करिए कंटेंट में
First one.
फर्स्ट 447 वाला.
Lord, I am praying mine should not be disposed of along with that because I am covered by the main judgment. I really did not. Otherwise, I will again suffer, Lord, several years of litigation.
We consider.
last submission, those observations will not in the order of contempt, not party that may not come in our way if you file a petition. That's all.
IA number may I just note the same.
IA number 19147 of 2022.
Yes.
application stand disposed of with an observation that it will be open for the applicants to approach the High Court for appropriate relief if they are claiming that appointments on their individual rights, public merits, which may be considered in accordance with law and his own merits.
Same.
My lord,
Just
same
not same order.
Not the observations, my lord, the observations will not come in order.
We'll consider that. We are going to clarify that.
Same order can then happen in 193303 also. Because otherwise, I would say, Lord, I would really.
Correct. 193303 also. Same order.
And same order, 2nd December to be vacated.
We'll consider council.
Also, I in
That should happen, otherwise we can't go there.
Okay, we'll consider.
Same order. 196996.
196996.
196996.
Only one additional.
197091 also.
19
7091.
19
Not in only one additional fact.
7091.
Okay, same order.
Not in only one additional fact. I was a civil appeal appellant here.
We'll clarify.
I'm not a writ petitioner there, but I was a civil appeal
Try
here.
to see, we will not see to it that anybody's rights are prejudiced.
That's right.
We consider it also. On the contrary, we would not have passed that order of protecting the service
I
of
appreciate
others.
it, but I'm only saying, Lord, if your Lordship send us back to the High Court, please reconsider that also.
Most probably after clarification, you may not have to go for also.
So that's what I'm saying. If your Lordship clarified.
We'll clarify. Yes,
My lord, I am the last one.
we are the last one.
I think
My
I'm
lord,
left
I am the
out.
last voice. My lord, I am the last voice, my lord. But let me put my case, my lord. I am on IN number 196602 and 192284 of 2022, my lord. My status is, my lord, I am in a non-scheduled area, selected high on the list.
That is like Mr. Diwan, eh?
Yeah, there is one difference, my lord. That, once the appointment was not taking place, we filed the writ petition in the High Court. High Court directed the government to appoint within 2 weeks. They did not appoint. A contempt was issued to them by the High Court. Against that contempt, my lord, the state came before my lord, and that contempt was tagged along with the main contempt. So we are before the High Court, my lord.
Okay.
And one thing, my lord, but this so far the 2nd December already concerned, my lord. We do not have our own grievances, my lord. But only consider, but this has been confined to those who have been appointed, my lord. This should be also confined to those who were selected and waiting for the appointment, my lord. If that comes,
Not 197014.
my lord, notes are my here. I have just given my notes. My lord, take it. Yes.
No, 197014, my lord. My prayer is similar to that of Mr. Diwan, my lord.
Okay, we'll consider.
My
1970.
IA number 193256 similar.
We give you all your numbers, sir. Like write down on your application note. Like Mr. Diwan, correct? Or Miss Mona, or vice so and so.
Our is like
Not
also
very
Okay, madam.
I've given the note to
Who are
the
you?
Lordships. Your Lordships, I'm already the appointed persons. There's only a suggestion I'm making. How everybody's rights can be worked out, Your
No.
Lordships. I'm just making Lordships will just
We are
give
not
my
going
note
to
for a second.
like it.
Lordships, I've handed over, Your Lordships.
We are not going to reopen everything.